Good evening. Today's March 21st, 2019. The 32nd meeting of the 23rd Council will come to order. Tonight is a special meeting. All councilors are present this evening. If someone's not here, they'll be arriving shortly. We are now going into the moment of silence led by the Pledge of Allegiance by Councilor Jones. Thank you. Civic Plaza parking passes are provided for members of the public. You can obtain a parking pass from council staff at the sign-up table. The council, if needed, will take a break at approximately 7 p.m. this evening. We are on item 3, proclamations and presentations. We have none. Item 4, administration question and answer period. Councilors, are there any questions for the administration? Seeing none, we move on to announcements. Councilor Betton. I will read his announcement. There will be a Rail Yards Advisory Board meeting on Tuesday, March 26th at 8:30 a.m. in the Council Committee Room on the 9th floor. Councilor Davis.
Thank you, Madam President. There will be an Albuquerque-Bernalillo County Government Commission meeting on Thursday, March 28th at 5 p.m. in this chamber.
Thank you. So now we are on item 6, final actions. So we're not gonna have general public comment. We'll just have the comment during this. Okay. So Councilor Betton and Winter, second committee sub 023.
Thank you, Madam President. I move a due pass on committee sub 023, amending Chapter 9, Article 4, Part 1, ROA 1994, the Police Oversight Ordinance.
Second.
There's a motion and a second for a due pass of committee sub
And Madam
023.
Madam Chair, we do have amendments that we read at our last meeting, but we'd like to have hear public comment and then probably at least some of these amendments we could move tonight. I think Councilor Winter and my intention would be that we not pass the bill tonight, but that we might, on some of the less controversial amendments, or even if they are controversial, hear them and vote on them if that's the wish of the councilors who are sponsoring them.
So what's this pleasure of the sponsors to move the amendments before public comment or after? After? Okay, so then we will go on to public comment. Our first speaker this evening is Mr. Rudolph Serrano, followed by Tad Naminsky, followed by Peter Simonson.
Madam Clarissa Peña, members of the council, it's hard to try to fix APD just by just look at them. We already know, what they are. I think they're making a lot of progress, the old PD to the new PD, but I think the changes have to go from inside the force. I haven't seen a lot of that coming up yet. I haven't seen these boards do nothing but, just to pamper a little bit, the force. I think there's more important things like the way APD charges everybody with a felony when they just do a misdemeanor to try to, get a conviction. That's something that we don't see, we don't point out, and that's costing us millions. Just to tell you one example, I'm the best mariachi in town. You pay $350,000 because I sang a song, and I'm gonna sing a little bit, and you tell me when you're willing to spend out of your pocket $250,000 just because I'm singing. Con el alma herida por un gran cariño que sin condiciones le brindé mi amor. Estoy en esta cantina con una botella. Is that something you will pay $250,000 not to hear? Because it's just too close to your block. You know, because I did 7 months in jail for that. You know, and I'm still waiting. It went through, that's without the 17 judges, 36, prosecutors, and I'm still in probation. You know, I think we need a lot more work. Thank you.
Thank you, Mr. Serrano. Tad Naminsky.
Thank you. My my name Ted Nemisk. Excuse me. Let me just begin this way and start from A. But before I start with A, it is all over the cell phone website. We, as public, never, that was says, public never throws the cops. That never will happen again. And that is, I'm directing to A, section 1A. So, trust between civilian and police. How we can trust police if they when they destroying, adding lapel cameras. It is evidence. It is criminal. Same thing city council does it, own office too. Editing. So let's go back to police. APD. Yeah, here is chief, deputy chief. I hope you hear me because that's going to be also all over because people watching me. So anyway, civilian B. Ensure that the civilian police oversight body function independently as possible from executive and legislative branches. Do we have branches here? False. That means you are unconstitutional. It's only one branch. Are you a legislation branch? How a legislation? Now, you want to take away power of subpoena from the board? Wrong. Board supposed to be above the director, oversight. And the board not supposed to rubber stamp it when it comes to directed to chief.
Thank you. Peter Simonson, followed by Nancy Konigsberg, followed by Dan Reagan.
Madam President, members of the council, Peter Simonson. I'm the executive director for the ACLU, but I'm here on behalf of the APD Forward Coalition. Thank you again to the sponsors of this legislation for such a conscientious effort to try and repair some of the problems with the existing CPOA ordinance. APD Forward strongly supports the amendments that Councilor Benton has put forward, and we thank the councilor for paying such close attention to some of our past comments about the substitute bill. We don't really have any concerns about or any objections to either Councilor Gibson's or Councilor Jones' amendments. We do have concerns about Councilor Sanchez's amendments, and I may be able to get into just a couple of those. On Councilor Benton's amendments, I just want to point out, among all of those, which we all support, the simplifying of the language around subpoenas, I think, is particularly important. And so we would strongly urge the council to pass that amendment. Where Councilor Sanchez's amendments are concerned, we are concerned that removing the percentage of the, removing the calculation of the CPOA budget from a percentage of the APD budget could allow the department to the agency to be sort of underfunded into obscurity or into irrelevance. And that was, in fact, an amendment, one of the top amendments, one of the most important recommendations that the task force to reform the original CPOA or Police Oversight Commission had made. We don't take a particular position on the at-will language that Councilor Sanchez was suggesting. Our main concern would be that the executive director does in fact have due process to you file a grievance about the way that he or she has been terminated. So,
Madam
Were
President.
you, okay, go ahead.
Yeah, can you finish your thought? And I'd also like to ask you a question about what your thought is on the whole proposed bill that we have and the work that's been done on it.
it's been, thank you, Councilor Winter, Madam President. I think overall, we're very happy with where you have taken the ordinance. I think it makes a number of major, significant, worthwhile improvements. The adding subpoena authority, I think, was one of our major concerns, and so the bill tries to do that. I think we're very happy with the work so far. I could go into more and more detail, but there's a lot there. There would be a lot to unpack. We're also very happy that the council has not amended out the provision that would require the CPOA and the board to devote most of its attention to policy matters, systemic issues, patterns of abuse, so on and so forth. I know that the CPOA, the board is actually struggling with those things right now. And I would hope that there's more discussion about how we can ensure that that body really does focus on those systemic issues. I think there's some unanimity of opinion on that, not just with our coalition, but even with the APOA. I don't want to speak for them, but it's my understanding that they also see that as an important focus. So I think it's incumbent on that board to really find a way to make sure that it's living up to that requirement.
Thank you.
Thanks.
Counselor Borrego, sorry, Mr.
Sir,
Simonson.
Could you speak a little more about the question of due process?
Councilor Borrego, yes, Madam President, members of the council. I don't know the city's personnel policies. I don't know, and I'm not a labor lawyer. I'm not a lawyer at all. So I don't really know what the implications of designating the executive director an at-will employee, striking the contractual reference. I don't know if, I've heard it said that it's not possible for an employee of a quasi-independent body created within the city to be a contractual employee. I don't know the truth or falseness of that. So that's, I don't know that I can actually say with any sort of expertise whether we think one way or the other. But due process, I do think it is important that if the executive director is subject to an at-will arrangement with the board, that if he believes he's been wrongfully terminated, that there is some way that he can, some place that he can grieve that finding, I guess, is our conclusion. Does that answer your question? Thank you.
Thank you. Our next speaker is Nancy Cohensberg, followed by Dan Reagan.
I'm a little shorter. Good evening, Madam President, City Council members. Nancy Koenigsberg. I am a member of APD Forward. I, like Mr. Simonson, was on the Police Oversight Task Force that drafted the initial recommendations for the revised ordinance. I want to follow up on a couple of things, some points. I agree with Mr. Simonson about the recommendation on the budget. One of our concerns in the Oversight Task Force was but it would be possible to underfund the oversight process to the point of it being, quite frankly, it would be a way to sabotage it and then say it doesn't work. So I think we'd really need to pay attention to that to assure the ability of the board to function. I want to point out one particular amendment that we're strongly in favor of. It's amendment on mine. It's Amendment C, adding to the kinds of information that are considered best practices, recommendations, recognized research and policy development groups, forums, and consortiums, or other. The importance there is relying solely on law enforcement recommendations limits the ability to look at other kinds of recommendations for best practices, and we think it should be expanded. The other important point is on data. It's incredibly important that the board have access to raw data for two reasons. One, that was part of the initial ordinance as a way of actually trying to capture things. And two, if we're going to go ahead and have the POB do oversight of policy and practice, they should have access to raw data to be able to do that. If the data that's given to them is essentially censored, then they won't be able to do the job that the ordinance proposes that they do. So we would appreciate keeping the words raw data in there. Thank you.
Thank you. Mr. Dan Reagan, followed by Ed Harness, followed by Andres Valdez.
Thank you, Chairman, President, councilors. I'm a bit frustrated by this forum. There are 12 amendments. There's no way that any single person can address even 7 of those. On February 24th, I sent Brad and his policy analyst about 2 pages on 7 of the amendments. I asked and wanted to have a public meeting, and this is the public meeting, but I find it very frustrating that something like short-term rentals can have a public meeting that is not this format, which is very constrained. And it's just problematic because you're not listening or allowing the public to interact with you other than these 2 minutes. Very, very quickly, the issue of cutting back on funding, I find very dangerous. I think it's a very good thing, Mr. Sanchez, that we move it into the regular budget. But to remove a set amount is putting it at the whim of recessions, and somebody don't like what they're doing. And I would suggest that, as well as moving it into the city budget, the regular budget, that you still maintain and retain the ability for this body to have up to.
Madam President, Mr.
Councilor
Reagan,
Wicker.
I want you to go ahead and go through the amendments and tell us the ones that you have issues with.
Brad, I appreciate that. Let me stay with the funding piece. I think there's ample and replete instances at all levels of governments in the past several decades of agencies that got substantially or completely underfunded and unfunded. The IRS, the DOJ, the FBI, multiple state agencies in the last decade here, in part because the work they did was unflattering or inconvenient to those in power. So I would suggest the following wording for the italicized segment that Councilor Sanchez put in. The CPOA shall have a dedicated, adequate, and independent source of funding sufficient to allow the accomplishments of their duties and responsibilities. This funding will, if necessary, be equal up to 1/2 of the APD's annual budget. The CPOA will administer its own budget, yada, yada. I also note that in the figures that are in your amendment, if you do some factoring in FY16, the per case cost was $4,400 and some change. In FY17, it was $2,800. In FY18, it got down to $2,665. It seems to me that the current board has gotten better at what they're doing, and they've gotten more economical in handling more cases. So I don't think we need, as public, to be concerned that they're wasting resources. But not to keep substantial funding in place is to risk sliding back to where we were before. And I really don't think we can afford that. I really don't. On Amendment L, I know that the state of New Mexico is an at-will state, so I'm uncertain as to how any employee would not be at will, and I don't know why that's included in this, regardless of classification or nomenclature. I'm assuming that the city's classified system is some form of protection through formal process that some or many government workers have. I've heard stories of you can't fire some government employees for not doing their jobs. It would be helpful if you could enlighten me as to what classified services means from an employment point of view. On Amendment E, the last sentence of the explanation says that the CPOA shall enjoy subpoena authority over any of the subject matters such as profiling or illegal searches if they are relevant in the context of the CPC or an audit. And my comment is, if racial profiling, malicious abuse of process, illegal searches, detentions, or arrests are contained in the subpoena power, I think there would be positive reason to have them spelled out in the ordinance. If they are explicitly contained in the ordinance, then they will be more likely to become part of and remain in the consciousness of the APD folks who are responsible for training for and monitoring the performance of their officers. Having these elements explicitly in the ordinance would also remove a need for any quibbling over which aspects of a situation can and cannot be examined under a subpoena request. That clarity will aid in the speed with which investigations can be accomplished, which should yield more timely and more adequate conclusions and case reports being issued. On Amendment F, I agree with the APD Forward and ACLU that sharing a performance evaluation of the director this widely without a qualifying declaration from HR personnel perspective about confidentiality needed for and with such a disclosure could create circumstances where one or more of the recipients of said evaluation could end up stepping on a body part belonging to themselves. I worked in HR for 30 years. I understand that having to do that inside a city system can be even more painful than in some private settings. But you don't take personnel information about evaluations and spread it as far as it's envisioned in that recommended. That's my own personal. Under G, the last sentence in the explanation does not map to the information shared at several of the meetings. And basically, my understanding was that the council had been aware that there were the openings. The council had been aware, or the council were not aware that up to 70 people had put their names in. And so I do think that without tying it to it has to be this and it has to be this report, that on a regular basis, at least quarterly, there's a review, whether it's internal or at a meeting, that says, hey, here's where the CPOA stands. We got these openings, we got these people. There ought to be some regular awareness made in the council. On H, I'm in complete agreement that the CPOA meetings would be best conducted at CPOA offices rather than any city facility. And on I, as I read this amendment, I wondered about the extent to which all these components have not been included in investigation reports. I agree that all the elements, at least in summary form, should be included in the investigators' reports to the board. Again, I appreciate the extra time. I think that the council could have and could still have a more open forum if they only searched ways to have the public come in and say, here's where we're seeing this stuff happening. Thank you all very much. Appreciate your time.
Thank you, Mr. Reagan. Mr. Ed Harness, followed by Andres Valdez, followed by our last speaker of the evening, Mr. Jerry Worrell.
Madam President, good evening, and thank you for this opportunity. First off, I'd like to thank the entire body for the work that's been going on for this ordinance rewrite for, well, over a year now. And aside from the standalone amendments that are being discussed this evening, I think that what has been rewritten and amended into this new ordinance is certainly great steps forward in having the ordinance comply with the CASA and aiding the board and the CPOA in doing its work. Regarding the subpoena power, I believe that it should not be limited in scope. The CASA states that the subpoena power should be for the agency to carry out its duties. And those duties include civilian complaints that can have a range of topics. And where our experience shows that we need the subpoena power is not for APD or APD personnel. It is for businesses, for videotape, phone records, and for civilians that do not want to cooperate with an ongoing investigation. People that are witnesses that are essential to the investigation so that we can complete a full and fair investigation. Having the ability to subpoena them would aid us greatly. I brought for you today an example of a findings letter which I believe shows that Councilor Gibson's concerns about what the board is reviewing, I believe is answered in all of our findings letters. We encapsulate the complaint. We provide the policy that's being examined.
Councilor Benton.
Just ask that Mr. Harness be allowed to continue since he's particularly knowledgeable about the discussion.
Thank you, Madam President, City Council. It provides the policy that is examined, the backdrop, the evidence as it relates to that policy, and it also provides whether or not we believe that there was, well, we provide a finding. Sustained, not sustained, exonerated, unfounded. So that's an example for what the board reviews as a findings letter. I believe if the board is going to substitute its opinion for a case, for an investigation, I believe it's only fair to the parties that they should be obligated to review the entire investigative file. This is an example of an investigative file for that particular letter. We cannot capture all of that in the letter. And if the board is going to substitute its judgment based upon the investigation, I believe they need to look at the entire investigation. As it relates to the meetings place, we do have an obligation that we live stream our meetings. We have attempted to do that off-site, and we found that GovTV has great difficulty in accommodating that. So if you choose for us to meet other places, then I think there needs to be an accommodation for the requirement for the live streaming. Thank you very much. I'll be here for questions all evening long.
Madam President,
Councilor Winter.
Mr. Harness, let me ask you a question too. What's your overall thought of the proposed bill and the process?
Madam President, Councilor Winter, I think that this body has worked hard to get public comment. It's given us ample opportunity to us, and I mean the agency, the CPOA, and the POB, the board, ample opportunity to review, to discuss, to vote on, and to give its feedback. I think that this has been a very fair process to evaluate this ordinance as it moves forward, and I believe the ordinance as it is a positive step moving forward.
Thank you, Councilor Davis, followed by Councilor Borrego.
Thank you, Madam President. Mr. Harness, welcome. I'm glad you're here, and thank you for that. I wanted to just go back to the subpoena issue you brought up just a second, if you don't mind. You mentioned the need. You mentioned the need to have subpoena power, in particular, to sort of compel non-compliant civilian witnesses. I assume that means just complainants or witnesses standing on the street, sort of seeing what they might have seen what happened. That hits me as something that is an extraordinary ask, and I want to be sure we're thinking about that in the right way. You know, as a former officer, I've been on both sides of all of these things. As a supervisor, I've done these investigations. You're a police officer, at some point you will always get a complaint about something, and you want that process to be true and honest. But I'm concerned that, you know, as in general police work, like if a witness doesn't want to cooperate, they don't want to cooperate, and it is absolutely extraordinary for us to go to a court and compel them to do so. We don't have some of those laws in New Mexico. I'm concerned about the ability of the Police Oversight Board to compel people to speak against their decided on personal interest. Like, what is the need for that, and why would it be that the board would not otherwise say this witness, perhaps they could say this is unfounded, or we just can't make a decision because the witness who might give us that information is not available? Why would it be necessary to compel that person instead of just being able to say this is unfounded, or we're unable to make a decision because we lack that information?
Madam President, Councilor Davis, I think necessity might be a strong term. I think that the ability to gather all of the information for a case on which we can base a proper decision is what we would always strive for.
Sure.
So that we can make it as fair and as thorough and complete an investigation as possible. The person that does not want to come forward and cooperate has the ability to not quash the subpoena and not come forward. What I think what we would be dealing with is this gray area where there needs to be a bit of a nudge for somebody to come forward so that we can get information.
Sort of a
And
cooperating reluctant witness.
if somebody fully doesn't want to cooperate, then they have the right to attempt to quash the subpoena and still not go forward. They would have their due process.
Right. Thank you, sir, and I appreciate that, Madam President. If I can follow that, I'm just trying to think through this process, right, and how that works. Whether I own a convenience store and have business records, which are those video evidence, that I might not want to turn over, or I'm the business owner and I just don't want to testify in this case, or I say I didn't see anything and perhaps some other witness believes that I did. You know, it is an extraordinary thing to compel someone to testify or to do this thing. It's a specialized area of the law, and quashing subpoenas, we don't do that very often. It takes some level of most people can't do that on their own. And so there's an extra sort of necessity of resources to do that. I'm not opposed to the Police Oversight Board having the ability to subpoena records that are necessary from an uncooperative agency they have oversight of. I clearly think that's clear. I'm just thinking through the process of how we would compel residents of our city to cooperate in an investigation that's not criminal, or would not necessarily, you know, really this is a policy issue. It's a personnel issue and a policy issue. If there's something criminal, obviously we have a route to send that somewhere else where they can compel that. I'm stuck on that piece. I'm not opposed to it. I want to have that conversation, mainly because it's an extraordinary power we would give to this board that we don't necessarily give to our police officers or other agencies in the city on a regular basis or on a deliberate basis. And I'm curious, and I want us to think very deliberately about how we do that, and whether that extraordinary power should apply to should be used on ordinary citizens, or whether it's more appropriately directed to the city or other city agencies. And I would appreciate any thought you have on that. I'm stuck on that, and I want to have that conversation.
Madam President, Councilor Davis, I believe that our position is simply bringing us in alignment with the CASA, of which the city was a party and of which they agreed to these paragraphs, and outlining that power.
Thank you. Councilor Borrego.
Mr. Harness, thank you. I appreciate your coming tonight and listening to your comments. My concern, is in receiving this letter, is that it discusses individual and basically, a process that took place, I guess. And I don't know if it's already been resolved or not, but I would rather not receive it. So if I can give that back to you, I'd appreciate it.
Madam President, Vice President Borrego, this is a findings letter that is from a case that's old and closed, and this letter is a matter of public record already.
Thank you, Mr. Harness. Andres Valdez, again followed by our final speaker this evening, Mr. Jerry Worrell.
Thank you, Madam Chair, Councilman. I'm here. I'm actually wearing 3 hats. I'm, of course, or Vecinos United Executive Director. I'm also Ward Chairman of Democratic Party 25C. I'm also on the Community Policing Council of the Southeast Area Command, and I think it's very important to have subpoena powers to their fullest extent as is being proposed, and that there's nothing like having to say the truth or having people say the truth, and how else can you do it? I don't think people in our society, when we seek justice, ought to be treated like babies and say, oh, well, you shouldn't be compelled to say the truth. So I think that's important. Also, I wanted to bring up another item. Basically, I was pretty concerned with this editorial by the Albuquerque Journal where this guy's house is arrested and there's no warrant, there's no police reports on file, no arrests, no police video recording of the whole incident. And in the midst of the whole Department of Justice investigation, it almost sounds as though we're going through a mechanical process to make people think that we're actually holding police accountable, when in fact it sounds as though they're not being held accountable at all, and it's all a dog and pony show, as I've said many times. I think it's really concerning. I think City Council needs to compel the right people to seriously look into this matter. Thank you.
Thank you, Mr. Valdez. Jerry Worrell.
Evening, Madam Chair and City Councilors. I'm Jerry Worrell, President of the West Side Coalition. My function as President of the Coalition, which I've been for the last 8 years, is to speak for them. And on an issue like this, I have nothing for you because we have not taken it up. And I think that I find that problematic. I think you're all aware of us enough to know that the West Side Coalition never met a windmill we didn't want to take a tilt at. So, and this is one we did not. And that escaped me and escaped the West Side Coalition, I think points to a deficiency we have in communicating with one another what is important and what we ought to be involved in. So my message tonight is I wished I had something for you on this matter, but I'm speaking more to the process that we need to be better at communicating with one another on issues that are this important, that we get the feedback from the 27 neighborhood homeowner associations that I represent. So I wished I had something for you, but I do not. Thank you.
Councilor Borrego.
Mr. Worrell, I think, thank you for being here this evening. You guys are involved in so many things. I don't know how you find the time, but I would also like to say that I think there's still time to send comments, at least I think after tonight we still have a little bit of time. So if you all wanted to submit those in writing, that would probably be appropriate.
Madam Chairman, Councilor Borrego, thank you. That is on our executive committee meeting tomorrow morning at 8 o'clock. where we will go through all the windmills we're dealing with, and we'll add this one to the list, and hopefully we will get something back to you immediately. Our meeting then will be the first Wednesday in April, and we'll hopefully have a resolution for you at that time. Thank you.
Thank you. So that's the final speaker this evening. We are back on the bill. Councillor Winter or Benton, did you want to begin moving the amendments or talking about them?
Thank you, Madam President. I'd like to kind of think what the feel of the council is regarding the amendments. So I know that we're not going to move this, we move the bill tonight, we're not going to vote on it, we're going to move it to the next city council meeting. And I know that there has been quite a bit of input here on the amendments. I don't know if we want to get more input or give folks another chance to do the amendments and then take them to the final meeting, but I'm open, I'm not sure. I just want to know what the will of the council is.
Councillor Davis, Benton? Councillor Benton.
Just from my own perspective, I think there are a few amendments that are, as I described them, I think less controversial perhaps, and may require continued discussion before our next meeting. There are others that, at least in my opinion, are fairly innocuous, and it would be nice to clear the decks on those if it's the will of council, and just go one at a time. So if you'll indulge me, I can bring forth the ones I want, but meanwhile, let's hear from the other councilors.
Councillor Gibson.
Thank you, Madam President. I would also like to tackle these, maybe not, I don't think we necessarily should vote on all of them, but at least, you know, some of them, the simpler ones, and maybe even have some discussion on the weightier matters. Thank you.
Okay, well, with that, I think what we'll do is, I would really like to start by having Mr. Melendres just kind of walk us through the process again. I know that's been a timeline. I know there's some confusion in terms of the communication, but I just really want the public to know that the council and the staff have really done a lot of outreach to work with many groups, and there's been opportunity for public comment, and I know there's never enough. I mean, I've been in that seat before where you just, and if you didn't learn about it, because some of these neighborhood associations, coalitions, they have so many things that they have to attend and to address, and sometimes we overlook some of these things, and it's unfortunate, but just for the assurance of folks like that to know that there's really been some experts and some community people that have come forward and given some really thoughtful, good input to part of this process that's been going on for over a year. So, Mr. Melendres, can you do that once more?
Thank you, Madam Chair. Compared to a more relatively normal council process and the trajectory of a bill, this particular ordinance amendment has had significant presentation at various forums. And the bill was originally introduced during the summer of 2018. From that time, it was referred to the City Council's Finance and Government Operations Committee, where it made several appearances and had at least a couple of strongly attended and well-debated hearings before that committee. That process resulted in 2 separate committee subs before that committee, the second of which is now before the council before you tonight. In addition to the process through the Finance Committee, the City Council set aside 2 special study session meetings, specifically for the council to hear from stakeholders and interested persons about this particular ordinance and what might be done in order to improve the process for the Civilian Police Oversight Agency and the Police Oversight Board. In addition, the bill has been before the City Council on 2 separate occasions where people have been invited to come and participate. Now we're having a special meeting before the City Council for that same exact purpose, reserving time in this chamber specifically to debate and discuss this particular bill and none others. And I understand that the council will again defer this bill at least one more time to further that debate and to allow additional discussion. So it's been quite a long process, multiple opportunities, and as you mentioned, people always have the opportunity to reach out to their counselors even outside of a meeting, and I know that several counselors have met independently with various groups and stakeholders and people relative to this, all of which informs the process and brings it back into the ultimate debate.
Thank you, Mr. Melendez. I appreciate that. So with that, I think we'll move on to the amendments. And Councilor Benton, did you want to, floor amendment number 1, which is labeled A, you want to get started there?
Thank you, Madam Chair. I'll move floor amendment number A, which we would label number 1. This is on page 2, lines 28 through 31. Allow the stricken language to remain. So just for explanation, in the previous floor sub, or in the floor sub presently, there's stricken language that this amendment would put back in. And that language reads as follows: the CPOA is accountable to, but independent from, the mayor. I just described that incorrectly. We did strike this language in the floor sub, and this would restore that language. The CPOA is accountable to, but independent from, the mayor, the city attorney's office, the city council, and APD, the CPOA, et cetera. So this would maintain that language very simply.
Madam President, Councilor Benton, this one is a little bit, the way that the amendment is written kind of makes it hard to follow, so I want to just make a quick correction to make sure that everybody understands that amendment. The ordinance as written today, without any changes, has some language in the general heading of the Civilian Police Oversight Agency that there is hereby created a civilian police oversight agency as an independent agency of city government, not a part of either the city administration or city council. That was the language as it exists today. The bill proposes to change that language to say that the CPOA is accountable to but independent from the mayor, the city attorney's office, the city council, and APD. So with this amendment, it would take back the language to the original ordinance, which would simply continue to say that it's an independent agency of government, not part of the city administration or council, and it would remove the language about independent but accountable to APD, the mayor, the city attorney's office, and city council.
Madam Chair, so the key language that in there really, since this is somewhat redundant, is "and accountable to."
Madam President, Councilor Benton, I think that's a fair way to characterize that.
And I do support this amendment, which is the reason I moved it, not just for discussion. I do support this amendment because I do feel that language of saying "and accountable to" creates some uncertainty, in my mind anyway, as written, about the independence of the CPOA. And I didn't hear a second. But.
So we're good? Yeah, we need a second. There's a motion and a second for floor amendment number 1. All those in favor say yes.
Yes.
All opposed, no. Motion passes. We're back on the bill. Floor amendment number 2.
Thank you, Madam Chair. This is the amendment labeled B in the packet. And this states on page 8, line 3, insert the following language after the period. APD shall provide POB members, the director, and CPOA staff with reasonable access to APD premises, files, documents, reports, data, including APD raw data, and other materials that are reasonably necessary for this purpose. And the explanation is that this amendment is intended to clarify that APD is required to allow the CPO access to its data, including raw data. So raw data, we don't anticipate that this would be in every case that raw data would be necessary, as I understand it, but there is some which certainly the agency would need to digest just the basics that were originally reported.
Okay, so there was a motion and a second, and then Councilor Davis, did you want to speak?
Thank you, Madam President. I just wanted to follow up to the question I asked on Monday, just to clarify with the sponsor and maybe with Mr. Melendez. The language here specifically mentions it shall provide POB members, the director, and staff with reasonable access. I just wonder if our intent there with our aligning of language could be better served by just saying the board. I know it seems like a simple answer, but I want to be sure that we're particular of whether individual members of their own accord can access that data, or whether we intend for the board as an organization to set its own policy and procedure for how it does that. And I wonder if the sponsor has any issue, or Mr. Melendez has any thought on how that could be interpreted, since I'm not a lawyer, but.
Madam President, Councilor Davis, the ability of the board to access raw data, I think, is an important issue for the Police Oversight Board. And the nature of the data that they would be accessing has relative levels of sensitivity, and already built into the ordinance in this process, there's some data within APD that cannot leave APD. And so there is, and likely for the raw data, we'd want to be able to preserve, the city might be interested in preserving the process of allowing the individual board members to have access to that to the extent it helps inform a decision, for example, on a policy recommendation. And so as drafted, it would preserve that opportunity for, in the event that the director could not retrieve the data, copy it, and then share it with the board, it would preserve their ability to go to APD under the secured sort of premise there and review the data for their own edification and take that knowledge with them without necessarily removing or jeopardizing the confidentiality of the data.
Thank you, Madam President. Thanks, Mr. Melendez. And just sort of in context, though, I think, do we feel like there's appropriate protections to be sure that, say, an individual member could not demand raw data individually from APD or make an individual appointment for something that was outside the scope of an investigation before the board? Or do we need to clarify that? I think that's
Madam President, Councilor Davis, there's not a provision here about the motions that the board would need to go through in order to access that data. It sort of seems to contemplate that it's within the, if it's within the scope of what they're doing, they would be able to go and access that. But I think if the council's interest is to make sure that APD gets to preserve people's ability to access that only for quote-unquote official purposes, that's language that could likely be drafted in, and we might want to hear from CPOA representatives on how that would work for them.
Thank you, Mr. Melendez and Madam President. I don't believe we've had a particular issue with this. I'm just trying to think ahead of some of the issues that have come up or the concerns that have been raised. So I'll defer to the sponsor. I don't think it's something we need to edit in this unless the sponsor wants to do so. But.
Councilor Jones.
Thank you, Madam President. And I have a question, please, of the sponsor, if it's his will to table this until we've heard the Amendment J in our packet, which says, and I'll ask Mr. Melendez to clarify this, it says board members shall rely on the CPOA professional investigative staff to perform the investigations called for under this ordinance and shall not independently investigate any matters before the board. Does this contradict that, or does it follow? Mr. Melendez, if you'd help me with that.
Madam President, Councilor Jones, I think that they can and should be read together and that they would not contradict each other if read together, because the CPOA and the POB have a couple of different functions. One is their investigation and evaluation of civilian police complaints, in which case, to the extent that they were independently going to evaluate this raw data for that purpose, that would be improper. And with if both this amendment and the other J pass, then it would simply say that their ability to do this would only be within the confines of an appropriate circumstance. And that circumstance could be where the investigation file that the director has prepared references a certain piece of data that they would like to observe for themselves, and that would probably be an appropriate circumstance. Or the other would be in the event that they are trying to investigate policy recommendations, and they need access to data to help inform what the issues are or what's out there so that they can make the best policy recommendation. So I think they could be read together and are not necessarily inconsistent. You would just have to comply with both.
Councilor Jones.
Thank you, Madam Chair. And so would you recommend that we vote on these at the same time right now, so there's no question, I mean, not at the same time, but back to back?
Madam President, as the way that you've described them and the relationship, and since they're both sort of, we're thinking about them at the same time, that would seem like a reasonable approach.
Thank you, Mr. Melendez.
Councilor Benton.
And Madam Chair, I'm agreeable to that. If the co-sponsor is, I think, well, it's my amendment, but it seems to make sense, and I appreciate that discussion. I have been remiss in not already asking the administration to speak if they wish about these individually and where we are. I'd like to do that on each of the amendments.
Okay, before we go to the administration, just let me have Councilor Borrego ask her question, and then we'll do that.
So on Amendment B, reasonable access, what is reasonable access considered? It doesn't define it, so, and, you know, I go back to when I worked for the city, and I worked for the city for a long time and had to respond to various legal matters and personnel issues. And I know that there is already a law, I guess, in place that people can come and access information from the city. And there's you make a request and that information has to be provided. So is that equivalent to that, or are we, I just want to know that we're not like, you know, I mean, is it a different level, or how does that, I mean, it's really kind of confusing to me because there's already a process in place.
Madam President, Councilor Borrego, the ordinance, as it's been administered for the last 4 years, has already had a provision in it relative to reasonable access. This particular amendment deals more directly with raw data in the way that it's incorporated here. And so there's already a course of dealing between the CPOA and APD about how that access is administered, and it's probably different than the one that we're kind of discussing about how the public would have reasonable access to things. And so I don't know that we've heard from the CPOA that issue of whether or not access has been reasonable or not has been problematic. And absent that, I would assume that course of dealing that they've had in that reasonable access has probably been okay. I would imagine that it's something like during business hours, when staff is available, those types of things. So I think that those types of considerations would be read into that reasonableness issue. The alternative is to try to define the circumstances that would or wouldn't be reasonable, and that may be a legitimate policy path to go down as well, but I don't know that we've heard that as being an issue that needs to be resolved.
I don't know, I mean, just asking the sponsor, since you guys worked on this, was that a discussion item at all?
I don't think it was. I think this was, my sense is it was put in sort of as an understanding or a term of art, if you will. I don't know if that's not a legal term, I'm sure, but rather an artistic term. So, I mean, I guess I would like to ask both, and full disclosure, we did discuss many of these with APD Forward, see if they have any objection to, first of all, to combining these two amendments, and secondly, with regard to that language, and then ask the same of Mr. Harness.
Mr. Simonson, if you can go first, and then followed by Mr. Harness.
Madam President, Councilor Benton, if I understand correctly, the question is, would APD Forward not object to combining the amendment? The it's Amendment B on my page.
Correct.
And
J.
Councilor Jones and Jay, I believe we do not have any objections to that.
And any thoughts of this thing of whether the words reasonable access are perhaps too vague?
No, Councilor Benton, no, we did not think that was too vague. As I recall, when we were drafting that language, I believe we had seen reasonable access used in other parts of the ordinance. I hope I'm not wrong about that.
I think that's correct.
It seemed like it was a reasonable thing to incorporate.
Okay,
so.
thank you.
Thank you.
And just real quickly before Mr. Harness, I think that's correct, that term is used.
Madam President, Councilor, Benton, it is, and that's what I was referring to, is it's been used for the past 4 years, and there hasn't been, nobody has said that reasonable access has been denied to the level that it should be defined more clearly.
And I mean, in the legal world, this kind of languages sometimes becomes subject to contention, but only when it's egregious, if I
Madam President, Councilor Benton, it can. I mean, standards of reasonableness are prevalent in all kinds of legislation in the law, and it's one of those things that it's not an issue until it becomes an issue. And I think that if the CPOA were to come to the council or councilors and say, we're not getting reasonable access because of A, B, or C reason, then you'd be in the position to help them fix that.
Thank you, Mr. Hernan. Thank you, Madam Chair.
Madam President, Councilor Benton, Councilor Jones, I don't believe that speaking on behalf of the CPOA, I don't believe that we would have any objection to combining the two. The data access is really, as Mr. Melendres pointed out, it's really about policy analysis and doing analysis of data trends by our own analysis folks as opposed to the APD analysis folks. So there's that level of independence so that we get the raw numbers, and that if we draw the same conclusions as APD, Dr. Winograd, then we know that everything is in sync. So the raw data access really is about policy and much less about individual investigation work.
Thank you.
Thank you. So there was actually a motion and a second for floor amendment number 2. And before I go to the administration, I think, Councilor Benton, did you want to make a motion to table it until we get to?
Yeah, Madam Chair, thank you. I don't think we need to table it. I think I agree to the friendly amendment to combine this with Amendment J.
Madam President, Councilor Benton, so I just want to clarify, because it gets a little bit tricky when you do an amendment to an amendment. So for with that motion, what you're voting on is Amendment B, and now you've moved to amend Amendment B to include Amendment J. So
All right.
that motion will require
Okay,
a
thank you.
second and a vote, and then you'll vote on the actual amendment, which will be
All
the
right.
combination of the two.
Thank you. So moved.
Second. Second.
So there's a motion and a second to include Amendment B with Amendment J. So all those in favor, was there a motion? There was a motion second. All those in favor say yes?
Yes.
Opposed, no. Motion passes. Now, Amendment B and J will now become floor amendment 2. And there's no more A, B, or J. So floor amendment 2. So, Councilor Benton, do you want to make a motion to pass floor amendment 2?
Madam President, Council, I think you've moved it and seconded it.
motion
And
is
now you've
already-
amended it, and now you just need to vote on it if you're ready.
So, Madam Chair, if we could hear from administration, if they have any comment.
Absolutely. Did
Thank
you want to
you.
go first? Okay. So I just wanted to ask the administration if they can actually just comment on Amendment 1 and then 2, since you didn't have the opportunity to.
Thank you, Madam President. As far as the administration is concerned, we feel like we would like to support the independence of this, and I would say that the administration does not have any comments on the 2 amendments.
Thank you. So we have a motion and a second for floor
Madam Chair.
amendment. Oh, do we have someone else? Oh, Councilor Davis.
I'm sorry, I don't want to belabor this point. I just want to give an opportunity to address a question that came up in a previous hearing, and Mr. Melendres is prepared to answer it very quickly. Mr. Melendres, since we've incorporated Amendment J, which mentioned the independence of the investigation and sort of the code of conduct, sort of piece of code of conduct for how the investigations are done, there was a question in one of our study sessions about whether how board members could discuss items that were before the board. Open investigations, for example, and sort of extrajudicial or outside the scope of the hearing comments. I just want to clarify for those following along at home that don't have all these stacks of papers with us. We've addressed that in the committee sub or in one of the versions thereof, and there are some rules about that. Could you just give us a top line on that?
Madam President, Councilor Davis, yes. So the context of that discussion was to take measures to help maintain the impartiality of the board both in appearance and in fact. And so the J that was amended into B and is now as Amendment 2 speaks to that. The committee sub also speaks to that as a result of those discussions at the study sessions, and in fact includes language that the board would have to remain impartial in their deliberations and decisions, refrain from ex parte communication relating to matters outside of a properly noticed meeting, and would have to refrain from prejudgment on civilian complaints coming before the board until they've reviewed all the facts and heard all the information. So those factors go toward that issue of helping maintain impartiality and objectiveness both in appearance and in fact prior to a hearing.
Thank you, Ms. Melendez. And I just wanted to make that clear because I think it goes to Councilor Jones's earlier Amendment J about the independence and the nature of those, and I think we've resolved those early issues and questions well. So thank you, Madam President.
Thank you, Councilor Gibson.
Thank you, Madam President. So I think I'm the only one who's confused here. It's not the first time, won't be the last time. So Amendment B seems to give much, greater access, hopefully, I think is what they're trying to say, reasonable access to board members, the director, and the CPOA staff. And I'm presuming CPOA staff means the investigative staff. Okay, so I get that. J seems to contradict that. J says board members shall rely on the CPOA staff to perform investigations. So B seems to, give direct access to these different places to board members, of course, the director and the CPO staff. But on J says, but it's only the staff who will be performing investigations. So am I the only one who sees a contradiction there? Help me understand it. Maybe one of the sponsors can help me understand.
Madam President, Councilor Gibson, I think I'll offer maybe an explanation that might be helpful. Mr. Harness's comments that he just made, I think, are the most helpful in clarifying that. And what Mr. Harness just said, if I understood him correctly, and I think I did, was that this provision is related more to the board's policy development function. The board's function and the CPOA's function really is comprised of two major components: reviewing of civilian police complaints and policy development. And so this access would be more in the context of their policy development and less in the context of investigations. And that's why the two can live together and not be contradictory. And I think that's clear if you read the ordinance as a whole.
That's very helpful. Oh, I'm sorry, if I may, that's very helpful. So should this not indicate policy on
Madam President, Councilor Gibson, that's another really good question. And the amendment, looking at it on the page, doesn't tell the full story, because this amendment is actually housed within a subsection that deals exclusively with policy development.
Okay, we ready? Okay, so there's a motion and a second for floor amendment number 2. All those in favor say yes.
Yes.
Opposed, no. Motion passes. We are now on C, which will become a floor amendment number 3. Councilor Benton.
Thank you, Madam President. Floor Amendment 3 would read on page 8, line 9, insert the following language before the period. The language is, and to recommendations by recognized research and policy development groups, forums, consortiums, or similar. And this language recognizes that in making policy recommendations, the POB or board should be able to draw from a number of sources in recommending policy changes to APD, including police best practices that have been used by other departments. This amendment was recommended by APD Forward, would expand the definition of what constitutes police best practices from just those practices that other police departments have found to be effective to also include recommendations from policy research groups. With this change, the full definition of police best practices would read as follows. Quote, police best practices, end quote, refers to law enforcement methods or techniques based upon the experience and outcomes of other police departments or law enforcement agencies that have documented superior results compared to other practices, and to recommendations by recognized research policy development groups, forums, consortiums, or similar.
So there's a motion and a second for floor amendment number 3. Are there any questions from the councilors? The administration, would you like to comment, or did you already, I stepped away to get water. Did you say you support all the amendments?
Madam President, thank you. No, what I said was that we are going to remain impartial.
Oh, okay. To all the amendments, okay.
Thank you.
So you're leaving it all on us, huh? Okay, so with that, there's a motion and a second for floor amendment number 3. All those in favor say yes. Yes. Opposed, no. Motion passes. We are now on D, floor amendment number 4. Councillor Betton.
Madam President, for discussion, I'll move the floor amendment number 4. I know we've got some, I've heard some various discussions about this, but I think it's sort of a key. It's one of the keys to the recommendation from APD Forward.
Second.
So this states, delete subsections 2, 3, and 4 on page 13, line 30 through page 14, line 8, and delete subsections 6 and 7 on page 14, lines 12 through 33. In place thereof, insert the following. Prior to seeking a subpoena, the executive director must make a reasonable attempt to exhaust all other avenues for obtaining information sought. Subpoenas shall be served in a manner that complies with all requirements for administrative subpoenas under New Mexico law. And I think that speaks for itself, but you know, this does change language that some consider to be too cumbersome in subsections 2, 3, 4, 6, and 7, and intrudes perhaps too greatly upon the POB's ability to set internal procedures for itself. APD Forward recommended the above changes in lieu of these sections, which deal with notice to various individuals within the city about the need for information, documentation by the director about the steps already taken that were unsuccessful in getting the information, and a standard that must be met in order for the POB to issue a subpoena.
So there was a motion and a second. Any comments, questions from the councilors? Councillor Gibson. Yes.
So I think that there's some case law about this, and I wonder if we could hear from city legal, please.
You said you guys were going to be indifferent. No, just joking. Go ahead.
Well, to be clear, I'm here as the city attorney, and I'm not part of the administration or the council. I'm here to give council and advice on whether the language in the ordinance or the proposed amendments conflict with law or with CASA. So my comments tonight are going to be limited to that, not to any policy matter, Madam President. But however, paragraph 283 of the court-approved settlement agreement, or CASA, does mandate that the city shall provide the CPOA with subpoena authority. However, the language that is recommended by APD Forward is in the amendment. We have some concerns not relating to the board itself, but to the due process protections afforded to those subjected to those subpoenas. And so I will, with the council's permission, turn it over to Lindsay Van Meter from the city attorney's office, who is attending her first city council meeting tonight, by the way, but to go into further detail about that. And just to be clear for the council, I know we have pledged to work directly with APD Forward and to discuss the subpoena matter. Our office has not yet done that and been able to reach out. I spoke with Mr. Simonson and apologized that we weren't able to discuss that before, but we will be meeting with him next week to discuss in more detail than Ms. Van Meter will tonight, but I will turn the floor over to her.
Thank you, Madam President and Councillor Gibson. There was a recent Supreme Court case from the New Mexico Supreme Court in Ray Chavez, 2017, New Mexico Supreme Court 12. In this case, an assistant district attorney was issuing subpoenas. He was opening civil cases and issuing subpoenas without giving notice to the individual whose records were being subpoenaed. And the Supreme Court had two significant concerns with it. One was related to the fact that this was a workaround the Fourth Amendment to get criminal information, and the other one is relevant for your purposes. And I would like to just read quickly the particular language. The court stated that because the subpoenas were unconnected to pending judicial actions, the third parties whose information was being sought were not parties. They were not notified, and they had no opportunity to contest the release of their personal information. This is especially troublesome in the few cases where the subpoenas sought private information, including medical records, CYFD records, and utility records. Furthermore, in general, the practice of issuing subpoenas outside the authority and acquiescence of a court or a grand jury poses foreseeable and alarming risks to the fundamental rights of ordinary citizens. A person may have a right to decline to cooperate with a police investigation. Once a subpoena is issued properly, it deprives the recipient of the right not to cooperate. A subpoena that issues improperly but has the guise of authority and carries the threat of punishment falsely suggests that the recipient is legally required to answer and therefore has lost the right not to respond. This is misleading and unfair and represents an abuse of the government's substantial power and responsibility. So this is particularly important for circumstances such as which the CPOA may be interested in issuing subpoenas, for example, to third party, to a phone company who has records of a person's phone calls, or to Metropolitan Detention Center who has records regarding inmates. The person about whom those records pertain isn't going to get notice. And so this is the same sort of circumstances as what the court was mentioning. So I suggest that many of the provisions that are in Committee Substitute 2, while they may seem onerous, they're there for a particular reason to provide that due process, and they will make the particular committee substitute more able to withstand a challenge based on due process. One other thing to consider with regard to the language that's in Committee Substitute 2 is that certain of these provisions are also for transparency, to make a record of the reasons that the subpoena is sought, and to comply with another case and other case law which governs the administrative process for receiving subpoenas, which is different than the process in which courts follow. And those cases require that in order for an administrative subpoena to be properly issued, the inquiry must be within the authority of the agency, the demand must not be too indefinite, and the information must be reasonably relevant to the purpose of the investigation. If it doesn't meet those particular requirements, a person can challenge it in court and it may be stricken. So I'm happy to talk through each of the paragraphs one by one or the particular amendments in more detail if you would like. I defer to you.
Thank you, Councillor Benton.
Thank you to the City Attorney's Office for your diligence on this, and we do, of course, appreciate your advice. And with that, for the time being, and pending hopefully a discussion soon with the advocates for this amendment, that we withdraw the amendment if that's the correct procedure at this time.
Okay. So we don't have to vote on that, correct? We just withdraw it?
Madam President, that's sufficient to withdraw.
Okay, thank you. So now we are on item E, which will become a floor amendment number 4. Did I have?
So.
Oh, yeah, okay.
To clarify.
Okay, yeah.
Madam President, Councilor Benton, so it was 4, but for record purposes, it was moved and seconded. Even though it was withdrawn, it still constitutes 4. It was just not acted upon.
Okay, I understand. Thank you. So this will be floor amendment number 5. This is labeled E in the packet. And this states on page 13, line 29, add a comma after the word complaint. And this was the brilliant suggestion of Mr. Melendres after some lengthy discussion about what this really means, and it's a great emphasis of the importance of good grammar. But what this really does by adding this comma, it makes clear that without the comma, there was lack of clarity as to whether there was a limit on the CPOA's subpoena authority to only those CPC reviews or audits where an improper use of force was alleged. And by adding the comma, it makes clear that the subpoena authority, as it relates to any subject matter, not just use of force, such as, as an example, profiling or illegal searches or things of that nature, are all within the purview of the agency. So that's what this is about.
There's a motion, a second for floor amendment number 5. Counselors, administration, all those in favor say yes.
Yes.
Opposed, no. Motion passes. We are now on floor amendment number 6. Counselor Benton.
Thank you, Madam President. This would be floor amendment number 6, and I'll move it. This one is another one that may merit some more attention, but this states that delete the following language on page 19, light 32 through page 20, line 1. This language states a copy, this would be to delete this language. A copy of these performance evaluations shall be delivered to the chief of police, the mayor, and the president of the city council for receipt by the council. And this was the language I believe we've heard about, and I'm in agreement with this. I'm not moving this just for discussion, but I know there might be some, so that's the motion.
There's a motion and a second for floor amendment number 6. Any discussion? What did you say? Oh, I thought you were pointing to Councilor Winter. Councilor Davis.
Thank you, Madam President. And I want to ask the sponsor, I may just kick it over here to staff again. I think what we saw in sort of this last review, we've just completed the very first, I think what is it, a 3-year process with the executive director, and just went through that renewal. It was a hard process for everybody involved because it wasn't very clear exactly who gets to judge whom by what and what standards are used. And I think there was a desire from the folks that I heard from the council and the public to be sure not only that the decision made by the Police Oversight Board, whether it's in retention or recommendation of retention or replacement, whatever that is, was done with some deliberance and process by which there was some certainty, both for the director and the board, and that normally comes through a performance evaluation, however we create that. I'm not intimately familiar with the city's personnel codes in this regard, but we received a memo from the board, just for the public to know, from the board president outlining their big picture deliberations and their summaries, and then we were able to ask follow-up questions. I want to be sure that if we don't, I understand the need to maybe not publish the technical aspect of a performance evaluation. However, this is a position that person comes in knowing that they have an independent oversight, that this board makes decisions about their hiring, their performance, and they have some additional obligations other city employees don't have. I want us to be sure that if we're protecting the 4 corners of the evaluation, that we do so in a way that the folks who have to judge the process have access to just like the Police Oversight Board should have access to the full case file of an officer or a procedure they're investigating. I think the folks who are evaluating that process need access to that as well. And so I'm not sure what the right answer here is, whether that is language that allows the city council or executive for us to do that in executive session to review more of that, what that is. I'm not satisfied that withholding the performance evaluation writ large from the public or for those who have to oversee the system is the best process for that. And so I sort of oppose this in principle. I'd like to have we can do that I think tonight and have a quick conversation about it. I'm just not sure I like I know you're doing this for discussion. I'm not sure I like the idea of saying we're not going to let the public or the overseers understand how the soup was made, sort of. And I see some members of our Police Oversight Board are in the audience who are sort of raising their hands and trying to get our attention at the discretion of the president, how we want to do that.
I think we'll actually, did you have a question for Mr. Melendez to respond to? Because Councilor Borrego actually wanted to comment.
I just want to lay that out there, that I'm not satisfied that this is the
Okay.
best answer to the problem, and I'm
Councilor
curious
Borrego.
for others.
Thank you.
Thank you, Madam President. And I think the issue of performance evaluations is incredibly important. I've served both as a city employee, a government employee, and in the private sector. And the issue of performance evaluations at the city level, basically there is for classified, and this was raised earlier about classified employees, there is a process that is already determined by our personnel office, or human resources office, I guess is what we call it now. And there is kind of a standard evaluation that, you know, most city employees have to undergo based on their classification sometimes, and sometimes it's general. In the case of the private sector, there's a number of types of performance evaluations that are available out there. And so I think that would be based on whether or not the director of the Police Oversight Board is a city employee or a contractor to the city. So I think it's really important, you know, how we look at this particular amendment in moving forward, and what that classification is going to be ultimately, whether that's going to be a city employee or it's going to, that position is going to be independent. So I just want to make that very clear for the record, and I don't think there's anybody here tonight from personnel or human resources that could address that, but I think that we need to be very careful about how we proceed with, you know, administratively, and I'm sure the administration has thought about this. Well, not the administration, the Police Oversight Board has thought about this issue. Thank you.
Thank you, Councilor Borrego. So I guess there was members of the board who wanted to make a couple of comments.
Madam Chair, while they're coming, can I make just a point of order? In the spirit of us combining all these odd letters, which we did a minute ago, I want to acknowledge that Councilor Sanchez also has a floor amendment here that deals with the director's classification that I think might be an important part of this conversation. If we intend to act on these tonight, I think we ought to consider whether we merge those two for this conversation.
Councilor
Thank you, Madam
Sanchez.
President. I do not have a problem with that. I think that works out well.
Okay. Hi.
Hi, Council President Pena, I'm sorry. Chantel Galloway, I'm with the Police Oversight Board and Chair of the Personnel Committee. Councilor Davis, we had this very same discussion ourselves around about the time that Executive Director Harness's contract came up for renewal, and meeting with some of the individual city councilors about the first deferral that happened when it came. And it raised some red flags for me. I come from a business background in HR, employment law, and all of that stuff, that the evaluation tool that had been used previously was overall largely subjective and did not tie in any way, shape, or form to the ordinance or the CASA, and that is problematic. We have to justify to you all why we want to retain our executive director, and that makes perfect sense to me. You guys control the purse strings. So we overhauled it. Kind of the busy bee work that we've been doing behind the scenes, we've overhauled it. You all should have received this week or Friday a copy of the new performance evaluation. We asked you all to participate by taking the online survey that closes tonight. And you will find that those changes are very objective. There is still room for comment from members of the community as to, you know, how the relationship building is going and things that are not quite so tangible. But when it comes to the ordinance and whether or not our executive director is checking off those boxes, whether he's checking off the boxes, he or she is checking off the boxes for the CASA, those things are now in place. And what we have discussed as a board kind of leading up to this ordinance revision is, while we don't believe that it is appropriate to give the nitty-gritty details to people who are not involved in the direct supervision of that employee, it is appropriate for us to distribute a summary of those findings and justify to you why we believe the executive director should be retained, what those like general scores were, maybe not every single one. Those are for us. But we are willing to kind of meet in the middle, and I do believe that that would mean striking this language that is proposed right now. Joanne?
My name is Joanne Fine, and I'm also on the POB and also serve on the Personnel Committee. And I think that when you look at the instrument we're talking about, we have a much greater degree of specificity as it relates to the ordinance itself. And I think that's intentional on our part. The instrument, the process, the timing, all of those things have now been put in place. And we would look forward to sharing all of that with you. And like Chantel said, a summary of the findings. You will actually be asked on an ongoing basis to participate in that evaluation as a stakeholder. As well as people in the CPCs, as well as other germane people at DOJ, other people who have a vested interest in this. So I just wanted to let you know that that process has been completely redone so that you have that and hopefully are comforted by that. I have a concern about anybody's personnel evaluation, the actual instrument itself and the results being spread widely. As a matter of fact, we just found out that somebody in the process of our sending out our evaluation let that evaluation, we just found it as we're sitting here on the Eye on Albuquerque. So obviously, we have to redo the evaluation. So forget the one you've done, or if you haven't done it, forget that. We're going to redo it because somebody had a need to put it out there. So we have done this by SurveyMonkey now, which is a much better process, and you're going to get a better product from us in terms of the accountability and our assessment of that. But we think we're the best people to assess that because we're doing it in the weeds all the time. So I just wanted to let you know that.
Additionally, I do have a copy of the evaluation tool, kind of the hard copy of it, as well as the metrics that are going to be used that are not completed, so we don't have that information back. I would be happy to share that with you if you all are interested to see how those categories are going to be scored, what the percentages look like, whether it's a yes or no, you either did this job or you didn't, or you did it some of the time, and what those ranges are. I'm happy to give those to you. I have them with me now, if that would be helpful in making this decision. Up to you.
Councilor Davis?
Thanks so much. And I think, the sponsor and I were just talking, I think we're close to something here. I would support striking this for exactly that reason, right? I think at the end of the day, you need an instrument and you need to be able to have a blunt conversation with somebody about their performance. And knowing that that would become a public document would deter someone from having a blunt conversation or being truthful on both sides. However, I think I would support this, and I think we'll maybe defer this a little bit or just pull this one. Let's deal with it a little bit later. But I'd love to see this come back to us with strike this and replace with some language that gives us certainty about the process, because I think this employee has some extraordinary authority and independence no other city employee has, and so I think we want to be sure that we insert the appropriate language to give everybody some certainty there. So.
And do we agree?
Thank you. Councilor Benton.
Thank you, Madam President. And with regard to Councilor Sanchez's amendment, which is labeled L, I'm amenable to that. But meanwhile, so I'm just stating that publicly here so we know and that we can proceed accordingly. But for the time being, publicly, I would like, and at this time procedurally, I would like to withdraw the amendment.
So since there was a motion and a second to withdraw, it still remains number 6, correct?
Madam President, correct.
Okay. So that was withdrawn. So now we are on floor amendment number 7. Councilor Benton.
Thank you, Madam President. This is the last of my amendments. This would be floor amendment number 7, and this is labeled G in the packet. Insert the following on page 10, line 9, after the period. the city council shall report out its progress on filling CPOA board vacancies on a quarterly basis. So I think this arose to be really clear and transparent. There was concern about the amount of time that the council took to move on filling out some of the vacancies in the board. And as stated in Mr. Melendres's explanation, he does have some concerns about there. I'd like to hear those from him, and so I'm moving this for discussion.
There's a motion and a second for floor amendment number 1.
7.
7, sorry.
Madam President, councilors, so this places a reporting requirement on the council that is sort of unique compared to anywhere else, and there's really no enforceability on it for the council. I mean, in the event that it's not reported out, there's really no remedy for that. So I think that historically, the filling of those vacancies hasn't really been an issue, and I think that Councilor Benton mentioned the kind of the leading instance of when that was an issue, but staff and the council have taken, strident efforts to kind of remedy that or in full swing in getting those appointments made at this point. It's likely that a quarterly report would not yield any information because I think the turnover on this board averages maybe a couple of members per year. And so, the report, to put the obligation of reporting quarterly and putting that resource into it for something that is otherwise sort of unenforceable would just result in several reports of no report. And so, the council has the authority to appoint and has been relatively diligent in the past in doing that, and it's hard to foresee a reason why that wouldn't move forward in the future. I think the hiccup with the appointments this last time was that there was some interest in waiting on this process because there were some changes in it that could have affected the composition and number of the board, but that seems to be behind us at this point.
Councilor Benton?
Again, I do appreciate Mr. Melendres's evaluation of this, and I also am very understanding of the frustration of some of the advocates and the board itself for the amount of time that was taken. I think we had some unique circumstances, and it's my belief that the council, and I should say this council because we can't bind future councils to what they might do, but I think we have set up a process for processing the applications for vacancies, for which we maintain a very arm's length. And I know of no instance where so far during a pretty otherwise successful rollout of this ordinance and this system of civilian oversight, where councilors have tried to really meddle with these selections. That has not occurred, and I think our whole intent was with a great deal of attention to the general community and the stakeholders in this when we first wrote it, that this would be the way we would operate, and I think I hope that will become institutionalized. So I share Mr. Melendres's concern about this, and again, I don't want to withdraw it altogether. I think this still merits more discussion, but I'm willing to again withdraw this, and we can still discuss it at our next meeting. But also open to a vote if the council would like to do so.
Councilor Davis.
Thank you. Mr. Melendres, can you remind me, we've been through so many different versions of these things. Did we ever settle on this is focusing on the council side, which I think is incredibly important, as you said. Like, I think there's some transparency that needs to happen in terms of our progress and towards doing that. But did we come up with a formal process? Have we ever come up with a formal process for the CPOA to notify the council that a vacancy exists by a certain date that would trigger some action by the council, as opposed to someone who has not attended for a number of meetings or perhaps has given notice to the board, but that may not have been communicated to the council? Is there a formal process for that?
Madam President, Councilor Davis, it depends on your definition of formal. So
no.
So yes and no. So if a board member does not attend for a number of meetings, that invokes a formal responsibility on behalf of the city clerk to take some action relative to that position, and that would be the formal notice process. Formally, but not sort of written in an ordinance, the city council has a staff person that staffs for the council the Civilian Police Oversight Board. And that staff person is sort of the liaison that receives those communications from the Police Oversight Board. And so it's institutionalized that that's the process. And when those vacancies occur, they are made to that staff person that comes back and triggers the vacancy filling process within the council services office and filters that up to the city council.
Thank you, sir. And I just might ask, and for the purpose of this discussion, if we're not going to do it tonight, I think that's fine. I think it's an informal process, but I think there could be an argument could be made that perhaps that has also not been sufficient over time in every instance where there was an urgency felt by the board and perhaps not by the council in determining how many members there were, especially for some of these votes where they may be quorum or other issues together. So I'd just be wondering if we ought to also, maybe if we do pass this tonight or pass on this tonight to another meeting, also consider whether we just add a sentence that sort of requires the Police Oversight Board to give formal notice, like the ECs and other things we get saying this person's on or this person's gone, so that we have a more formal record. And I like to do that in some future amendment before we pass.
Were you going to respond to that, Councilor Benton? Because I'm.
No, please,
Okay,
anyone who
Councilor
wants to.
Gibson.
Okay, my comments are really pretty short. I think this really talks about one of the most important parts of this the CPOA and its success, and that's the membership, the people who are serving on that, and the selection for that. I understand, I've heard again tonight that we have 70 applicants, and that's wonderful, but that is certainly not what we've had in the past, in the recent past. It's been very, very low. And of course, we want people who are able to serve and dedicate the time. And because we ask so much from all of these members, and truly I appreciate everything that you all do, it's not really an easy thing to have happen, or not an easy decision to make, I think, sometimes. So I don't think that a report from City Council is really, I don't know, I don't think that that's really going to be very, contribute very much, unless there are times when, like right now, when there are folks or positions that need to be filled. But, the reason we got 70, because this has been in the news and people are more aware of it. I mean, I don't have real strong feelings on this, except I think, anything that deals with making sure that we have, the right kind of folks that we, that we're selecting for this board, that is really important. I'm just not really sure that, a quarterly report is going to be very useful. That's all I have.
Councilor Sanchez?
Thank you, Madam President. I am very sympathetic towards the board members because they have waited a long time for this council not to appoint, but by the recommendation of our staff, to get the 3 new members in. Again, I don't think this is necessary, and I would hope in the future that we will not have this vacancy of 1/3 of the entire board not being present, because I know their workload has continued to increase by those vacancies. So hopefully we can get you the board members, but I'm not sure for this particular amendment. I don't think it'll make any difference. It's going to be our due diligence and our staff to assure that we get board members to your board as quickly as possible.
Councilor Benton?
Madam President, thank you. And I appreciate the comments of the council, and I appreciate the sense of urgency that's expressed in the amendment that was provided to us by APD Forward. And I wanted to ask, I'm going to withdraw the amendment and move it, but I would like to ask staff to see if is there some kind of language that we could assert the responsibility of the council without requiring a reporting of some kind, or assert in some way along those lines. And I'll just ask Mr. Melendres that now, whether he wants to answer the question or not is okay.
Madam President, Councilor Benton, I think so. The ordinance does clearly call for this body to make those appointments, and there are a number of signals that we could include that would speak to the relative urgency of those appointments. I don't know if I'd want to suggest that language right now, but that's certainly something we could continue to look at.
Thank you. And Madam Chair, just for the record, for anyone who didn't know, part of the reason was there was, at the higher levels of the council staff, there was, I think there was a present company excluded, that there was a sense that because we were considering, there was a concern by the council of that we had lost members, and that maybe a smaller board might be better. And we had floated that out there, I think, in the first version of the bill. And at that time, previous Director of Council Services, I think, made that call that maybe we needed to hold off. So that was my understanding, and just to clear the air on that, but certainly was not with any intent to weaken the board or to weaken the process. So I will ask that this amendment be withdrawn for the time being.
So floor amendment number 7 is being withdrawn. We are now on floor amendment number 8. Councillor Gibson.
Thank you, Madam President. So this amendment inserts the following between the words housed and in, and the boards shall hold its meetings. And the intent of this amendment is as follows. The CPA shall be housed and the board shall hold its meetings in a facility that is separate from any police presence and is located outside the Albuquerque Bernalillo Government Center, the police department, and all of the police substations. This amendment would require that POB meetings be held outside City Hall. The ordinance already requires that the CPOA offices be housed outside City Hall, a measure that's intended to help promote the agency's appearance of independence. Having the meetings outside of City Hall may go further in promoting independence in fact and in appearance. So I don't know where other people are on this, but other counselors, but I am very much in favor of showing independence wherever and however that can be done. And their meetings, I understand that they get televised. They can be televised. We have GovTV, who happily goes all around the city, and certainly could accommodate them in whatever venue they would like.
Councillor Winter.
Thank you, Madam President. I think from what I'm hearing is that GovTV is having a hard time being able to get those meetings from a different location. So I guess the point we've got to decide what's more important. Is it the perceived independence by moving them to another building and not have them televised, at least at this point, or keeping them here and having it televised? So I guess we, at least at this point, until GovTV can find a way to televise off-site, what is more important?
Councillor Gibson, followed by Councillor Borrego.
Thank you. I was just going to ask, well, first of all, clarify that it's my understanding that they need to be televised, but not necessarily live. And I'm not aware of any problems that GovTV has. I mean, they're real good at press conferences all over, so. in various parts of the city. So I think any other venue within city buildings should be something that they can handle. So is there anybody here from GovTV or anybody in the administration who might be able to speak to that? If not, maybe we can hear this later.
President Pena, Councilor Gibson, I'm happy to turn it over to Ms. Van Meter, but the CASA does not require that meetings are televised, but the current ordinance does prescribe that the meetings are televised, just as a point of order and clarification.
Right, but not necessarily live. So televised could be recorded.
Madam President, Councilor Gibson, that's an accurate reading.
Thank you.
Councilor Borrego.
Can I ask the POB members if you guys would come up and give us some insight on your thoughts? Because truly, these are your meetings, and they're, I'd like to hear what your thoughts are.
Madam President, council members, we did discuss this, and it is one of 2 points that we took a position on at our board meeting last week, and we do think that it's appropriate to be housed here. The question that you raised, Councilor Winter, about which is more important, that they be live or that they be aired on television, or that we maintain our independence. If we remove ourselves from televised board meetings, it limits the reach into the community, which is who we're there to serve. Without their input and an opportunity for them to know what's going on, or promoting that opportunity as much as possible, it kind of defeats the purpose of what we're here to do. And that's to bridge the community and the police department and find a way for this community and its police department to work together and to function, well together. I do have a copy of the piece about the meetings where it does call for live TV coverage for regularly scheduled meetings. It says only the regularly scheduled monthly meetings and special meetings held pursuant to submissions of petitions will be televised live on the appropriate government access channels. I'm going to let you, rather than me try and do something that I am, way out of my league on.
Mr. Harness, go ahead.
Yes, Madam Chair. And I just have the page, but it's page 9 of the rewrite of the ordinance. Meetings, the POB shall conduct regularly scheduled public meetings with a prepared agenda that is distributed in advance to the mayor, city council, chief of police, city attorney, that complies with the New Mexico Open Meetings Act. Each POB meeting will begin with the public comments, and only the regularly scheduled monthly meetings and special meetings held pursuant to submission petitions will be televised live. So the monthly meetings currently must be televised live in accordance with the ordinance.
So really, it seems to me like the question is regarding whether you continue your meetings in City Hall and whether that gives you the degree of independence that the council, and we all as a community agree that you should have. So I guess the bottom line is, if you have your meetings in City Hall or in City Government Center, does that take away from your independence?
I think the argument could be made that that's possible. I don't know that it's been an issue in and of itself that we meet here. I don't know has actually been an issue that anybody has vocalized, at least not on my time on the board, which is relatively short in all fairness. And I think that the board would be amenable to meeting someplace else if we already had arrangements for GovTV to video those meetings. I think that once we have that in place, it would be fine for us to meet elsewhere. But trying to put the cart before the horse, I think, would prove problematic, at least from our point of view.
Thank you. Councilor Sanchez.
Thank you, Madam President. I know years ago, some of the councilors had meetings in their district. The challenges that they faced was the cost. It was much more expensive to conduct the meetings outside of City Hall. Here you've got the cameras, you've got everything set up, the dais. They were going in early in the morning, setting up like a big table, you had manpower that was involved to basically conduct these public meetings, and that was one of the reasons that we decided to stop, because it was just too expensive. I like the intent of going out into the public. I still feel that the board has the independence that they need in conducting a meeting here in these chambers. It's worked out well in the past, and I think the intent is good, Councilor Gibson, but I feel what is working now will continue to work, and I would hope that they would still have the independence that they are required and do have, whether the meeting is here or in a public forum outside of City Hall.
Counselor Gibson.
Thank you, Madam President. I think we should hear from, I think, Ms. Van Meter. There's been some conversation. I think Ms. Van Meter has, was looking something up. Did you have something to add to this?
Thank you, Madam President and Councilor
Thank you,
Gibson.
Mr. Harness. Thank you.
The only other point worth mentioning is right after the sentence that Mr. Harness read regarding only the regularly scheduled monthly meetings and special meetings held pursuant to the submission of petitions will be televised live on the appropriate government access channel is another sentence. All other meetings of the board shall be videotaped and aired on the appropriate government access channel. However, there's no requirement for providing live television coverage. That last clause, it depends on whether you read it as applicable to both of those sentences or just the one. And I think, I don't know that this was an issue, at the time that the amendment was proposed. I think the thinking was that it could be done. So, I defer to your judgment on all of that.
Okay, thank you. Counselor Gibson?
Well, I guess I don't want to withdraw this. I'd like to get a little more information, so maybe we could just discuss this next meeting.
At the next meeting. So there was a motion and a second, so would she have to withdraw?
Madam President, Councilor Gibson, yeah, so you would need to withdraw tonight, but that wouldn't preclude you from bringing it back up next time.
Okay, so I should withdraw?
All that signaling is that you're not asking for a vote on it tonight, not that you're withdrawing forever.
Right.
Yeah, so you would need to withdraw.
So I'm sorry. I didn't
Yes,
hear
I'm
you.
sorry. So you would need to withdraw just to signal that you're not asking for a vote on it tonight.
Okay, all right. So I will withdraw my motion.
Okay, thank you. Counselor Sanchez?
Never mind, Madam President, there was never a motion made. I think it was just basically discussed.
There was a motion.
Madam President, I think we heard a motion and had noted it. It's been a while, though.
Counselor Gibson, floor amendment number 9.
Should I withdraw my withdrawal? No? Okay. Okay, so floor amendment number 9 is on page 3, line 7, adding the following language after the period. Board members shall rely on the CPOA professional.
Madam President?
Oh, wait a minute, I'm reading on the wrong one.
That's
me
item
back
J,
up
so let's go
one.
back to I.
Here we go. I'm sorry. This is on page 20, line 24. Insert the following after the period. In addition to the findings and recommendation, each investigation report shall at a minimum also include 1, a section outlining any relevant background and facts relating to the matter. 2, a listing of any relevant policies, procedures, or practices that are at issue. And 3, an analysis of the issues in the case. This amendment will help ensure that board members have relevant information and analysis presented to them in their board material to help guide their review and consideration. At present, it appears that board members do not get much written analysis or information about the cases they are considering unless they independently review the investigation file. Additional helpful information can be useful to help focus a decision-maker's analysis and help build comfort with their ultimate decision. To that, I would just add that it just provides a minimum and ensures some uniformity among reports. So I'm moving it.
Is that in the form? Yes, thank you. Thank you. So there's a motion and a second for floor amendment number 9. Any questions from the counselors? Administration? Counselor Gibson?
I urge your support.
There's a motion and a second for floor amendment number 9. All those in favor say yes. Yes. Opposed, no. Motion passes. We're not, J was included in amendment number 2. We are now on K, floor amendment number 10.
Thank you, Madam President. I move floor amendment number 10, and I will withdraw it after we discuss it.
There's a motion and a second for floor amendment number 10. Councilor Sanchez.
And this reads, 1, on page 3, lines 17 through 18, delete the following text, equal to at a minimum of 1/2 of APD's annual operation budget. And I know there was a couple of comments made by Mr. Simonson. I thank you for his input, and Mrs. Coensberg for her input. The reason I am looking at this, looking back at the approved budgets back in FY 16, 17, 18, the amount that was approved in the budget was $1,005,000 back in FY 16. The actual amount that was expended was $877,450. So there was a reversion back into the general fund budget, not into the public safety budget, of $127,550. And looking at the FY 17 budget, the approved budget was $984,000. The actual amount spent was $751,723 for a surplus and a reversion of $232,277. And in FY 18, the approved budget was $860,000. The actual amount spent was $732,944 for a surplus of $127,056 and a reversion once again into the general fund budget of $127,056. And also, we just recently passed legislation, this council, on a unanimous vote to increase the gross receipts taxes by 3/8 of a cent. We didn't go to the public to get that done. We've given our police officers this fiscal budget a 10% increase. I mean, so we have really put a lot of money into the Albuquerque Police Department budget to assure that we retain officers and that we also recruit new officers. And at the same time, this budget would increase by 1/2% of the entire budget. You know, I think like every other department within the city of Albuquerque, you know, the city council, the mayor's office, solid waste, any department in the city has to come before the council and present their budget to the council. I mean, we may not be providing enough money to the CPOA if they need additional money to do additional investigations. But again, I think it's the responsibility of the board to present a budget to the council each year, like every other department in the city does. You know, I think that now we at least have a dialogue with members of the board, with Mr. Harness, and I think we can work really well together to assure and not to sabotage. I know there was a comment made about trying to sabotage the budget of the APOA. That is not the intent, my intent at all. I'm just looking back at some of the history and the money that has been spent and some of the reversions that have gone back into the general operating fund and not into public safety.
So was that in the form of a motion?
Yeah, there's a motion and a second, but then I will
Motion, second already,
withdraw.
and then you're going to withdraw.
I
Okay.
think there's a couple of comments.
Oh, Councilor Benton, sorry.
I just want to appreciate, as usual, Councilor Sanchez' fiscal diligence.
Councilor Jones.
Thank you, Madam Chair. Councilor Sanchez, thank you. I think we've all been thinking this with that tax increase, and we definitely need to get a finite budget in this rather than an open-ended, so thank you.
And I'd like to ask our legal department, Mr. Aguilera, would like to comment?
Madam President, Councilor Sanchez, the CASA requires that the CPOA, POB be provided with a budget to carry out their necessary duties. Those duties include, only specifically, they're enumerated: investigate civilian complaints, review serious uses of force and officer-involved shootings, and making policy recommendations. The current proposed amendment does not conflict with the CASA. There is no provision in the CASA requiring the POB's, or the police oversight agency's budget to be tethered to the police department. As the council knows, the council has the responsibility to hold, you know, the board must be accountable to the city council. The council also has the responsibility to ensure that taxpayer dollars are preserved and are spent appropriately. By going through the budget process, that increases that level of transparency and accountability to the city council in a way that does not conflict with the CASA.
Thank you.
Any other questions?
I will
Councilor
withdraw.
Sanchez? Okay, so floor amendment number 10 is being withdrawn, and then the last one was combined with floor amendment number 6, correct? That is correct. Okay. So with that, we have gone through all the amendments this evening, and I've only gotten confused 10 times. So anyway, if there's no other questions, this meeting, no further businesses, special, nope. I thought we were.
I'm sorry. Just move deferral
Oh,
until
I'm
our
sorry.
next meeting.
There's a motion second for a deferral to the April 1st meeting. All those in favor say yes. Opposed, no. Motion passes. There be no further business. This special city council meeting is adjourned.